We all are facing the problems with our aging parents, and some of them have addressed their estate issues and some haven't. This is a very important arena for everyone. If you're over the age of 18, there are documents you should have. The first is an advanced healthcare directive, and that says this person is being designated to make decisions for me in the event I'm unconscious or incapable of making decisions for myself. This is a free document. You can get it at any major hospital. Go to your primary care physician. Ask him to help you fill it out, and he will. If you're afraid to do it that way, you can certainly contact an attorney, but there is no need to. The second thing that every individual needs to make sure of is that they have a will. A will tells somebody, this is what I wanted to have happen to my assets. Now, we've all heard from Suze Orman, you gotta have a trust. And I'm here to tell you that that's just not true. In California, believe it or not, very few individuals need to have a trust. They do need to have a will, and they do need to make sure that there's some efficacious manner to deal with their bank accounts, bonds, stocks, and real estate. And we've all been told we need a trust. A trust is a great mechanism for an attorney to charge you $2,000 or $3,000 to form it, and then $5,000 to $10,000 to help you manage it after that individual passes away. In California, you have the ability to go into a bank, a brokerage firm, and tell them, I'd like to make my accounts paid on death or transfer on death. That allows you to designate beneficiaries, which you can change at any time, and it doesn't have to be one, it can be in percentages. And all your beneficiaries would need to do is get a death certificate and show up to the institution. Pretty easy. Doesn't require an attorney, doesn't require an accountant, doesn't require anybody. Might need a little bit of assistance from the mortuary in getting that document that's saying the person has passed. Well, as of January 1st, 2016, California might be a difficult business state, but we've made it easier for those individuals who choose to retire and unfortunately pass away here. We now have a new deed, and it is called a transfer on death deed. It is revocable at any time. It has absolutely no effect, even though it must be recorded, until the person passes away. So again, you can change your designation of who that beneficiary is anytime. There is a caveat, however. It's only meant for single people. If you're married, California since 2005 has had a deed made specifically for you. All you have to do is have your title changed from your name to your name and your spouse's name as community property with the right of survivorship. With that designation, when a spouse passes, the property will automatically pass to the surviving spouse, and you'll receive a stepped-up basis. Now, I know stepped-up basis sounds very technical, but what that means is if you bought the property for $100,000 and now it's worth $500,000, there won't be any tax. You receive that stepped-up basis to $500,000 because it was a community property asset. So if you're single, make sure you see an attorney and get that transfer on death deed. If you're married, check the title to your real estate and make sure it says your name, your spouse's name, as community property with the right of survivorship. If you'd like me to discuss these matters with you more in depth, if you'd like to go over your particular situation and finances to see whether or not you do in fact need a trust, as some do, please feel free to schedule a consultation through my website. Technically, it's going to take 30 minutes to an hour.